So the next story that I have for you here is this one out of Georgia. There was recently a conclusion or partial conclusion to this case where Georgia high school students were subjected to a Fourth Amendment search, or rather an illegal search in violation of the Fourth Amendment. And they won $3 million against the sheriff. The sheriff was then indicted, 6-count indictment after controversial school search. What were the indictments? Sexual battery, violation of oath of office, and I guess other charges, I'm not sure. Then recently, the governor issued an executive order removing him from the office of sheriff of Worth County and appointing the deputy sheriff, I think, as his temporary replacement. So this is the amended complaint that they won $3 million from. Plaintiffs buying through their next friends and guardians, because these are children they sue through their parents, on behalf of themselves and the class alleged herein. This is a civil rights action arising from a mass search of 900 students at a Worth County high school at the direction of Sheriff Jeff Hobby. Plaintiffs bring this action to redress violations of the 4th and 14th Amendment of the U.S. Constitution. Plaintiffs' class representatives are 9 Worth County high school students were subjected to unlawful and intrusive searches. Defendants' mass search of all or nearly all of the high school students took place on Friday, April 14th, 2017. On that date, Sheriff Hobby and his deputies placed the high school on lockdown for 4 hours. About 40 uniformed officers from 5 law enforcement agencies arrived on school grounds. Educational programs were interrupted. Students were directed to remain in specified areas without explanation as to what was happening, and students' cell phones were seized. At about 8 a.m., defendants, under the direct orders and supervision of Sheriff Jeff Hobby, including some other officers, conducted a drug sweep, indiscriminately searching all or nearly all students' persons and clothes using police dogs to search their bags, classrooms, lockers, and cars. The sheriff's mass search included a hands-on body search of every or nearly every student in attendance at school that day, including students with disabilities. Defendants' searches of students were intrusive, performed in an aggressive manner, and done in full view of other students. For example, deputies ordered students to stand facing the wall with their hands and legs spread wide apart. Deputies touched and manipulated students' breasts and genitals. Deputies inserted fingers inside girls' bras, pulled up girls' bras, touching and partially exposing their bare breasts. Deputies touched girls' underwear by placing hands inside the waistbands of their pants or reaching up their dresses. Deputies touched girls' vaginal areas through their underwear. Deputies cupped or groped boys' genitals and touched their buttocks through their pants. Deputies had no warrant or other authority to perform a mass search on hundreds of public school children. The purported justification for this mass search was to discover drugs. To that end, Sheriff Hobby had a list of 13 students on a target list that he suspected of possessing drugs. The target list included only 3 students who were in school on April 14th. Defendants had no basis for suspecting any other student of involvement in unlawful activity. No illegal controlled substances or drug paraphernalia were discovered during the mass search. So let's stop for a second. You have a Fourth Amendment right against unreasonable search and seizure, and that is a recognized right. That is not a right that you leave at the door when you go to school, when you go to high school, or when you set foot in a government building, or when you work for a government authority or entity. The Fourth Amendment right to unreasonable search and seizures is definitely a little bit different when you are a high school student, but it is not suspended. You still have a right to due process of law before a search and seizure. What is the due process of law for a search and seizure? It's very complicated. Usually it means the officer needs some kind of probable cause or a warrant, and usually a warrant needs some kind of probable cause. There are different kinds of warrants, there are different levels of probable cause, and this is not a discussion of criminal policy and procedure and law. But the point is that you can't walk into a school, lock it down, and search everybody to see what you find. You have to have some kind of reasonable suspicion or probable cause that's recognized by the criminal law as it applies to these students, and in general for the whole public, but it applies slightly differently for these students. So he has to know this law, and he'd want to consult with his county's attorneys, the prosecution, the district attorney who's responsible for prosecuting these cases. The district attorney would want to approve all of this first, and preferably get a warrant. And that warrant is normally tailored to the specific kind of search and the people and the places that can be searched and all that. So apparently none of that happened, and that's a big deal. No illegal substances were found during the search. Defendants had no right to touch, pat down, or manipulate the body parts of plaintiffs or other students. Defendants had no right to search plaintiffs' clothes or undergarments. Defendants' unlawful conduct injured plaintiffs by causing them fear, embarrassment, stress, and humiliation. Plaintiffs seek damages and declaratory relief for members of the class of all students searched and seized by Worth County Sheriff's Office employees on April 14th. Let's see what else is in here. We're not going to go through the individual plaintiffs. Defendant Jeff Hobby is the sheriff of Worth County. He planned, organized, executed, directly supervised. He was present during the search, intended for his deputies to conduct the searches described herein, is liable, could have intervened. He acted under color of law. And then there are the other employees and deputies and officers and things are all listed here. There's no need to go through all of this. I think the major accusations have already been fleshed out. Sorry for your eyes. Class allegations. This is being done as a class action lawsuit. Plaintiffs bring this class individually, seek to certify. Class is so numerous that joinder is impracticable. Every class member's claim turns on the same question common to the class. The claims of the named plaintiffs are typical of the class. The plaintiffs will fairly and adequately protect the interests of the class. And then here's their statement of the facts. Hobby maintains a target list of people he intends to investigate because he suspects they have committed crimes. He placed 13 Worth County High School students on the target list. In late March 2017, he informed the principal that he planned to conduct a search at the school. He did not inform the principal that he planned to conduct a search of all or nearly all students at the school. The administration did not know or permit the defendants to conduct body searches of each student. The school resource officer was attending training and was unaware of the plan. Although he did not share his plan, it was his plan to conduct hands-on body searches. To ensure that a sufficient number of his officers would be present to search the school's 900 students, he ordered all of his deputies to report for work on the morning of the search. He personally ordered several defendants to search every or nearly every student, personally supervised it. Upon arriving at the school, he gave the principal a list of the 13 names. He ordered that the students on the target list be brought to the administrative offices and isolated there for the duration of the search. The 3 students in attendance that day whose names appeared on that list were brought to the administrative offices, and they were held until the search concluded. Defendant had no reason to believe that any student in school that day had any illegal substance or engaged in any otherwise unlawful activity. The school administration, not defendant, the school administration did not have any individualized suspicion or any reason to believe that any student in school that day, with the possible exception of the 3 students on the list, that they had any illegal substance or engaged in any unlawful activity. With respect to the plaintiffs who were subject to searches of their bras or underwear, defendants had no reasonable suspicion of danger and no reason to believe that any student was hiding any controlled substance or other prohibited item in their undergarments. At the request of the sheriff, the school made an official announcement over the intercom shortly after school began on the morning of April 14th, indicating the school was being placed on lockdown. This was the first time that teachers learned that law enforcement activity of any kind would be occurring at the school that day. Following the announcement of the lockdown, plaintiffs were confined to their first period classrooms, to the hallways immediately outside the classrooms, or to the gym. Their cell phones were seized, so they could not reach their parents. Plaintiffs were prevented from contacting their parents during the entire duration of the search. This is also a very big deal. Part of a student's due process rights is to be able to contact their parents and have their parents either represent them or gain representation, or at the very least be notified that the child's in trouble. The school is usually not allowed to start searching or enact certain strict punishments and things without first contacting the parents. It's another civil rights violation, basically. During the lockdown and mass search, defendants restricted students' access to restrooms. Some students were not permitted to go to the restroom for the entire 4-hour lockdown period. The deputies conducting the searches, including searches that involved touching undergarments, sometimes did not wear gloves and did not change their gloves between searches. Despite searching approximately 900 students, defendants did not discover any illegal drugs or drug paraphernalia. It goes into some specific allegations. This student's legs were kicked open, pulled their bra away from the body by underwire and flipped it up, slid hands down, ankles up to pelvic area, hands stopped on and cupped the vaginal area and buttocks. I'm not going to keep reading too much of this. You get the idea. It was an invasive search. Basically stopped short of a body cavity search. Defendants' unlawful mass search injured plaintiffs. Defendants' actions harmed plaintiffs by causing them injury, including anxiety, embarrassment, and humiliation. Experienced fear, shame, emotional distress. Damaged their ability to trust law enforcement officers and persons in positions of authority in general. Yeah, welcome to the club. That's a big deal. Let me make a point of that as well. Like, all of the other stuff is a big deal as well. But what law enforcement or other authorities miss when they overextend and they disrespect is that they are also establishing the basis, the foundation for all of the people that they don't like who say, cops are one way or another. Some of that's hyperbolic, some of that's extreme, but some of it is also just a genuine, founded lack of trust for authority. And in this case, whether or not he was trying to be a jerk, defendant Jeff Hobby, Sheriff Jeff Hobby, used his powers for more than his powers were to be used for, and now 900 students, or some significant portion of them, do not trust law enforcement, and are probably not going to cooperate very much with law enforcement in the future, or at the very least are going to cooperate only after asking themselves some very careful questions about how much they trust law enforcement. It is clearly established that law enforcement officers violate the Constitution when, at their own instigation, in an effort to obtain evidence of illegal drug possession, search and seize the body of any person, including a student, without probable cause. See State v. Young, Georgia, 1975, explaining that while attenuated Fourth Amendment protections apply to searches conducted by public school officials, remember I said that there were some limits, that the Fourth Amendment does have some limitations for schools and things, entirely without the participation of law enforcement officers are, of course, bound by the full panoply of the Fourth Amendment rights when searching students. So there you go. In Georgia, law enforcement officers have to observe the Fourth Amendment even for students. See also State v. KLM, requiring probable cause for the in-school search of a student by a law enforcement officer, even though the search was directed by the principal, because the officer was a law enforcement officer who participated in the search. So probable cause would be a higher standard than reasonable suspicion, meaning the officer needs more information and more cause to conduct a search. Unlike a school official, a police officer must have probable cause to search a suspect in Georgia. Probably generally speaking as well, but definitely in Georgia. It is clearly established that probable cause requires individualized suspicion, and that mere attendance at a large school at which a few students are suspected of possessing drugs is not sufficient to establish probable cause or otherwise render the search and seizure of a body of a student reasonable by and at the investigation or instigation of law enforcement officers for the purpose of obtaining evidence of illegal drug possession. See Ibarra v. Illinois, a person's mere propinquity. Wow, that's a new one. I haven't seen that. A person's proximation or locality to others independently suspected of criminal activity does not, without more, give rise to probable cause to search that person. where the standard is probable cause, a search or seizure of a person must be supported by probable cause particularized with respect to that person. See also Swint v. City of Wadley, probable cause to arrest one suspect and even probable cause to believe that a number of others or unidentified people had sold drugs in the establishment in the past does not give officers carte blanche to seize everyone who happened to be in the club when the two raids took place. Defendants had not obtained warrants to arrest or search plaintiffs. Plaintiffs did not consent to being seized or searched. None of the searches, including the searches of plaintiffs, occurred incident to lawful arrests. There are no exigent circumstances to justify the searches. These are all the reasons why searches can be conducted. Even if defendants had seized or searched the bodies of plaintiffs at the behest of school administrators, they would still have violated their rights. Defendants had fair warning that their conduct was unconstitutional because a mass search of nearly 900 public school children by law enforcement without any individualized suspicion clearly and obviously violates the Constitution. See Gray ex rel. Alexander v. Bostic, discussing obvious clarity cases in the school seizure context. This is from the 11th Circuit Court of Appeals. Based on the totality of circumstances, the searches and seizures of plaintiffs were plainly unreasonable. The conduct of defendants lies so obviously at the very core of what the Fourth Amendment prohibits that the unlawfulness of the conduct was readily apparent. The defendants are liable. Okay, so count 1 is an unconstitutional search and seizure. Count 2 is a violation of right to privacy. And that's it. And this was filed by the Southern Center for Human Rights. What do you think of that? That's pretty epic. And we know they won. They won $3 million, which is about $3,300 per student. I don't know how that's going to be distributed or what the agreements are there. But yeah, so if you're in school, this is not allowed to happen to you. What to do if it does? That's a good question. I leave that to you and your parents to discuss this case, especially if I'm actually addressing a high school student. It's illegal. You should definitely not become violent, but at the same time, how do you make it clear as a student that you're not allowing a search? So I'll tell you what I tell everybody. You can beat the ride, you can beat the time, but you can't beat the ride. So the ride in this case is the ride of the experience of being searched. So, you might have to suffer through that and then sue. That's more or less what you do. You should not physically try and oppose a sheriff, especially a sheriff with an ego large enough to think that he is above all of the First Amendment and Fourth Amendment law that we have in this country that was, like they said, clearly established. So there is a criminal case with assault charges, Ewan. If you hadn't seen that, there were 6 indictments returned. Let's see. The indictment says that sheriff violated the terms of his oath by ordering deputies to search students. It goes on to say that he and one of his deputies made physical contact with intimate parts of students' bodies. So it looks like there are some kind of assault, battery charges, oath of public office charges that have been filed. I was not able to find a PDF copy of that indictment immediately. So that's interesting. What do you think of that?